All right. Good morning. Republican Chairman of the House Labor and Industry Committee. We're once again back in Harrisburg after a fun-filled day yesterday of finally completing a budget for this fiscal year. It was very exciting. There were fireworks at the end. They released doves. Angelic noises from up on high came down. It was amazing. It was a good time. Did you guys enjoy it? It was great. It was great. No, enjoyed it. Yeah. Blogger. So we're here at our Liger Labor and Industry Government Efficiency Roundtables. We're here to discuss the fun and exciting world of workers' compensation. A little dry, but a very important topic as it adds a lot of costs to businesses. So we're going to make this fun and exciting, or try to. We won't have fireworks. There will not be probably angelic noises from on high. If that happens, I don't know what has occurred in this room, but I'm really excited about it. We know Pennsylvania doesn't have the best business climate. We know businesses are leaving. We know North Carolina, Florida, Texas, South Carolina. There's so many are eating our cake every single day. I like to remind everyone that North Carolina steals our people, our businesses, and our last congressional seats. So as these states are changing tax policies and labor policies, they're also looking at workers' comp. It is a decision businesses make, whether they want to go to somewhere or not. It is one of those things. It's not something we talk about, so we're going to do that today and discuss where we're at on workers' comp, what we can do better, and how we can help businesses and employees be successful here in Pennsylvania, because we want to take care of employees as well, but make sure we have the best business climate we can to keep and attract employers. With that, we'll do introductions to members, and I'll throw it over to Representative Chad Reeker, who has a bill on workers' comp and is very passionate about it. So I'll start. Chad?
Chad Reichert, 90th District, Franklin County.
Barb Gleim, 199th District, Cumberland County.
Joe Diorsi, 47th Legislative District, York County.
And virtually, we'll start with Rep. Rossi. Oh.
I'm sorry, you're starting with me, you said?
Leslie Rossi, District 59, Westmoreland County.
Go ahead, Rep. Barger.
Scott Barger, 80th Legislative District, Blair and Huntington counties.
Yep. Rep. Fink.
Wendy Fink, Legislative District 94, Southern York County.
You missed some really good traffic on 83 this morning. Rep. Anderson.
Representative Mark Anderson, 92nd District, Northern York County.
And Representative Cooper.
Good morning, Jill Cooper, Rep. District 55, Westmoreland County.
Great. Thanks, everyone. Appreciate it. And we'll turn it over to Rep. Reeker for opening comments.
Thank you, Mr. Chairman. So this bill was brought to me by our friends at the Chamber with the idea, again, of just improving working conditions in the business climate here in Pennsylvania. So Pennsylvania is very fortunate, along with other states, that workers' comp claims are going down. Our industries are safer than they have ever been. The unfortunate side of things is that workers' comp claims have become more and more expensive. Right now, our state law requires that employers post a list of at least 6 designated healthcare providers with specialties appropriate to the treatment of anticipated workforce industries or workplace industries, and the employee has the option to choose amongst them, and for the first 90 days of the claim. And this is all made known to the employee at the time of their employment, or if there's any changes or anything like that being made. All of the physicians all of the providers must be physicians that are located in the general area. But essentially what my bill looks to do is it looks to remove that 90-day cap on this, with the idea being that the providers that are identified by the employees have the best interest of both the employee and the worker in getting that person well and back into the workforce and earning money as quickly and as beneficially as possible to their long-term health. So the idea being that why would we want to change if an injury or a workplace incident takes longer than 90 days to resolve itself or needs additional treatment? Why do we want to switch horses in the middle of a treatment? So the idea is that by removing this 90-day limit, the employee, the injured worker, can stick with the person that they started their treatment with and continue on without having other things that might be unfortunately contradictory to what that physician has identified as the best course, again, to get that person healed and back into the workforce. Just a couple quick statistics. In 2024, 77% of all injured workers were treated using providers on an employee panel. 16% didn't use the panel, and 7 only used emergency care that was exempt. Overall, 86% of workers were at least moderately satisfied with the care that they received for the workplace injury. 82% of injured workers reported that the care they received for their work injury was similar or better quality than their routine health care. For injured workers who were treated by a provider listed by their employer, overall satisfaction was also high. 88% of injured workers who reported that they chose their own provider from the list were at least moderately satisfied. And 86% of injured workers reported that they asked their employer to help them choose a provider from the list, and they were also moderately satisfied. So what are we looking to do? So the bill will likely lead to a reduction in legal disputes over medical care if enacted. The goal of workers' compensation is to provide medical treatment and lost wages to an injured worker so that they can return to work whenever possible. When a claimant in a litigated claim switches to a provider selected by their attorney after a 90-day limit, they are more likely to be legal disputes over medical care and the medical conditions of the claimant. And by using panel providers for the life of the claim, the employer is much less likely to contest the need for specific treatments such as expensive surgery or medication, because the employer, usually with their insurance carrier, chose trusted providers to be designated on the list. Additionally, fewer instances of profiteering on prescription drugs like topical medications. According to the PA Workers' Comp Advisory Council, a significant rise in prescriptions for topical agents has driven a rise in the total cost of prescriptions per claim in PA. In recent years, profiteering was centered on physician dispensing and prescriptions for custom compound creams. The issue with topical agents seems to be the next step in the evolution of the earlier profiteering schemes. These prescriptions are not typically written by providers listed by employers, so by requiring the use of listed providers for the life of the workers' comp claim, House Bill 1998 is expected to lead to a reduction in this type of profiteering. So again, Mr. Chairman, the idea again is to provide workers with consistent care to ensure that they receive the treatment needed to re-enter the workforce as quickly as possible while reducing costs to our employers. I think that this bill is certainly a win-win and benefits both sides of the table.
Great. Thank you for that overview of your legislation. The written information members have either virtually or in your packets. We have the presenter's information, a copy of the 2024 Workers' Comp Medical Accessibility Study, a copy of a letter from the Workers' Compensation Advisory Council regarding an increase in the cost of pharmaceuticals in workers' comp, including the studies and data noticed in their letter. They're not in the packets, but we can get them to you if you want more information on them. And obviously a copy of House Bill 1998, which is a phenomenal bill number because that's the year I graduated high school. And then House Bill 1181, which is no significant historical reference to me whatsoever. But it's a great bill because it does the what more for a fix. With that, we have an awesome lineup of testifiers today. We have Alex Halper from the PA Chamber, Jonathan Greer from the Insurance Federation of Pennsylvania, Ramona Tanabe. Did I get your last name correct, Ramona? Tanabe?
Yes, thank you.
Thank you. Neil Dombrowski of the PA Defense Institute, Stephen Moore, PA Defense Institute, and Paul Fires of the PA Chamber. So with that, we'll just go in order. Start with Mr. Greer. Thank you.
Thank you for allowing me to go first. And I appreciate the opportunity and what I hope is a discussion, really, as opposed to a formal hearing on the issues that are of concern to us. When I must confess that when John Scarpato first reached out to me about this roundtable, and the topic was costly inefficiencies and abuses in the Pennsylvania comp system, my heart kind of skipped a beat because that is an issue that is near and dear to us. And the focus of our comments are going to be in the area of prescription drugs. And Representative, you referenced that previously. That is an area of ongoing interest to the General Assembly, an area of ongoing abuse. It is true that our comp system is relatively stable. I think that is because of, we're getting away from an industrialized-based economy and more of a service-based economy, so therefore the number of accidents and the severity of those accidents are not what they once were. That stability should, however, not mask some of the abuses that we're seeing in the comp system. And at the very top of that list for us is the area of prescription drug abuse. And I won't go through all of my comments, but my prepared remarks, but there are a couple statistics that I would like to point out to the members, that Pennsylvania has the highest average prescription drug price in the country at $300. We have the second highest prescription drug payments per claim at $2,262, and we have the second highest number of prescription drugs per claim at 7.6. That comes to us from the WCRI and the PCRB numbers. So obviously, we're unfortunately a leading state in this area, and this is not by any means a new area of concern. It is the case that under the Corbett administration, the General Assembly passed and the governor signed into law limitations on what was referred to at the time as physician dispensing. And that was where the provider was dispensing the drugs that he or she prescribed at the time. We placed limits on that, again, the details of which are in there in my prepared remarks. But that was an area at the time. Now, that was more than 10 years ago. I think that was in 2014 when we enacted that. I had to go back and look. Time has a way of getting away from you. So that was in 2014. That was the last major comp reform that the General Assembly enacted. The other issue that we advocated for before the General Assembly was to establish a drug formulary in workers' compensation, and to also, and this goes, Representative Reichert, to your point, URAC certification of the UROs. And you said something that really stuck with me, which is making sure that there's consistency of the care that we don't want variances. There's nothing good that comes of that. URAC certification of the UROs, of which there are, I think, 24, if not more, but that the department retains for utilization review, standardizing that process is something that was part of that bill. It passed the General Assembly. It was a very, Representative Grove, you were here at the time, that was a nasty fight, and we were able to get it over the goal line. Unfortunately, it was vetoed by Governor Wolf. So that kind of took a lot of wind out of the sails, frankly, of the desire to go into battle again for no win. So now, in terms of looking forward, yeah, we do have a lot of concerns with drugs, particularly compound topicals. Compound topicals are where you have various ingredients that are mixed together for a topical use. And again, my comments, sort of speak to some level of detail. But the problems with the compound topicals, one, it goes back to the URAC conversation. They're not FDA approved, and there's no standardization. So the clinical efficacy of these things is somewhat in question. I'm not saying that they're of no use, but because there's no standardization, there's really no oversight, that's a question. The other problem is because it falls outside of a benchmark pricing system, that you run into exorbitant charges. That, yes, there is a fee review process in place, but that is a costly, time-consuming process that is probably best to be avoided if we can. So the issue of compound topicals is a concern that we have. And I know in the packet, just going through it this morning before we started, the other area that is of concern involves what we refer to as the Red Book. And I don't know if anyone's familiar with the Red Book, but the Red Book is the pricing benchmark that was selected by the Bureau of Workers' Compensation pursuant to the Workers' Comp Act to establish 110% of average wholesale price for drugs. And there is litigation. I think the oral argument is scheduled for next week before the Pennsylvania Supreme Court because the Commonwealth Court found in a case that's called Federated Insurance, not the Insurance Federation, Federated Insurance v. Summit Pharmacy, which I think is a mail order pharmacy, an out-of-state mail order pharmacy, that the Commonwealth Court found in Federated that the Bureau's reliance of the Red Book to determining 110% of AWP is incorrect. That whatever the Red Book is, it's not, those numbers are not the average wholesale price as dictated by the statute. It's an interesting decision because intellectually it's honest. It's true. The Red Book, whatever it is, it's not AWP. It's really closer akin to the manufacturers. It's like the sticker price for the car that's determined by the manufacturer. The problem is it's practically deficient, because there is no pure AWP benchmark that the Bureau can align that statutory requirement to. It doesn't really exist. So for 30 years the Bureau had been tying 110% of AWP to the Red Book. What the Commonwealth Court said is that violates the statute because the Red Book is not AWP. So then the question becomes, okay, what is? And that's where we have all run into trouble trying to identify what the standard should be as it relates to the statute, or does the statute need to be changed? Because a pure AWP benchmark really doesn't exist, as best we can tell. We have some ideas as to, depending on what what the Supreme Court determines, we have some ideas for legislation in that area as to how that pricing methodology should, and again, it's in my prepared remarks. I won't go through it now, but unless you'd like me to, but that we have ideas for legislation. That would also apply to compounds, or apply to topical compounds, which is an area of significant abuse. But as we know, and we're sitting here, Representative Grove, you said the day after the budget, okay, that's something you have to get done. And it took us 4 months late to get it done, and it was not easy. So opening up the Comp Act in the absence of a real need to do it is going to be tough politically. I think we all know that because of the various interested parties that are going to be involved. We will probably not get a decision out of the Supreme Court, I'm guessing, till the second half of next year. It's a guess. I'm not sure that by September of 2026 we want to look for a big political fight 2 months before an election. So we don't. It's hard to predict the future, but we are preparing ideas for legislation if or when that moment arises where we need a legislative correction. That has been historically when we have delved into opening up the Comp Act. We just can't ignore this problem any longer. And perhaps the Supreme Court's decision in Federated might present such an opportunity.
Do you think the court will offer a remedy, or just say it's null and void in General Assembly? You have to.
It's a good question. There are a couple different things that could happen. One, they could remand the case back to Commonwealth Court and say, Bureau, you got to come. And then what the Bureau would do is they would come back with some other benchmark that's not AWP, and then that will present litigation. The court potentially could say that the Commonwealth Court took a too literal reading of the act. And therefore Red Book is fine for this purpose, et cetera, et cetera. But it's hard to say. But those are two possible scenarios. So I don't know if you want to do questions now or wait till the panelists okay. Those are my remarks. I mean, obviously there's more detail in my prepared remarks, but gotcha. I'm happy to answer any questions.
Yeah. Anybody want to jump in real quick? No? Mr. Halper.
Thank you, Chairman Grove, members of the committee. Appreciate the invitation to be part of this discussion. I'm Alex Halper with the PA Chamber. We represent about 10,000 business members throughout Pennsylvania, all industries, all sizes, all 67 counties. It's a very diverse group of employers, and one of the common threads, however, is they all have workers' comp insurance, which they're required to do. So this is a very relevant topic for the overall business community. I appreciate Chairman Grove framing this as a competitiveness issue, which it absolutely is. And I do think it is relevant that this hearing is happening the day after the budget resolution. Obviously a challenging process, and every year, and I think it's fair to say that in the years ahead, you all as lawmakers will confront this challenge of balancing a budget when there are increased costs, but not a desire to raise taxes. Of course, it's the answer to that puzzle is very simple, is more taxpayers. We need more. You don't have to raise the rate if you have more people paying those taxes. How you get there, of course, is the challenge. We, of course, at the PA Chamber see business, economic growth, and business attraction as a number one priority or number one way to address long-term budget challenges. People need jobs, businesses pay taxes. I know for many, it may not seem like workers' comp comes to mind right away when you think about a business climate and business attraction, but what I hear from our members, from Pennsylvania employers, particularly those who operate in multiple states, they absolutely cite workers' comp and the difficulties that they experience in Pennsylvania compared to other states. They absolutely cite it as a reason why Pennsylvania's business climate is not as attractive as other states. So we appreciate the focus on this issue. Definitely appreciate Representative Reichert introducing House Bill 1998, which we do support. And just a little bit of background in there, and I appreciate a number of comments from Representative Reichert describing the overall system. It is true, and Jonathan referenced our workers' comp system overall in the aggregate, on average, is generally stable. There, as Jonathan mentioned, the evolution of our economy, employers investing a lot more in workplace safety has reduced the overall number of accidents and claims, which helps keep the cost down. But again, as has been mentioned, the cost of individual claims continues to increase and increase beyond the rate of just general healthcare inflation. So if you're an employer who is dealing with a really challenging workers' compensation claim, suddenly that becomes your number one priority. And one of the themes we see in some of these challenging claims is when the wrong healthcare provider gets involved. Every stakeholder in the workers' compensation system should have the same priorities. That is for the individual to get healthy, to get back to full function, and to get back to work as soon as possible. Unfortunately, there are some actors out there who don't view that as the top priority and see our workers' compensation system as an opportunity for profit. And unfortunately, it's often the injured workers who are the victim, because the longer a claim gets drawn out, the better it is for those actors. There are a number of ways that states, over the decades, really. Workers' comp was passed in 1915, and over the decades, many states have identified strategies for improving their systems. Oftentimes, it's not reinventing the wheel; it's replicating what has generally worked in regular health care. In workers' compensation, you have a lot of states that will pass a prescription drug formulary or treatment guidelines. These are the pre-approved treatment regimens based on best practices, based on the evidence. If you're a doctor and you believe that your patient is unique and requires treatment beyond, you get approval for that. That is pretty standard. In Pennsylvania, the bill for prescription drugs got vetoed, and treatment guidelines have never been implemented. The other common strategy is to create a managed care system, like you have in Medicare, in Medicaid, in group health, where you have PPOs. It allows for providers to better coordinate among each other, and it keeps some of these bad actors out of the system. So yes, there is a cost containment focus, but and Representative Reichert mentioned, it is also, when you look at the numbers and the surveys, it is pro-worker. When workers, injured workers are participate in surveys, those who have access to panels simply have better outcomes. They're more satisfied with their care. You might have mentioned, Representative, the last survey that came out from Governor Shapiro's Department of Labor and Industry. When with the panel, 27% were extremely satisfied with their care, compared to 14% when workers did not have access to a panel. We also looked at, or they also looked at, the frequency of these injured workers getting re-injured or having to go back into treatment after their initial injury. When they had access to a panel, 95% of workers did not re-injure, compared to 86% who did not re-injure when there was no panel. I think even more relevant, within 6 months of the initial within 6 months of the initial injury, 11% of claimants re-injured when they did not have access to a panel, 0% re-injured when they treated through a panel, 0%. This is not about choosing between cost containment. It's one of those rare instances. This is not about choosing between cost containment and what's in the best interest of the injured worker. This is a way to really thread that needle. And we appreciate the focus on workers' comp, the focus on Representative Reichert's legislation, and thank you for the invitation.
Before we get to our next panel in person, we're going to go online to Ms. Tanabe of the Workers' Compensation Research Institute. She's going to, whenever you're ready, go ahead. And I don't know if you're sharing your screen or we have that. She'll do it. Okay. It is all yours.
I will share my screen.
Thank you.
Thank you. Thank you, Chairman Grove and members of the committee. My name is Ramona Tanabe, and I'm the president and CEO of the Workers' Compensation Research Institute. Before I share a few slides with measures and data on them, let me describe what I'll be sharing in a few words about who WCRI is. We are a non-for-profit research organization, and we provide public policy research in the field of workers' compensation. We're supported by all stakeholders in the workers' compensation space, and importantly, we don't take positions or make recommendations on the issues that we study. Rather, we provide research so that public policy discussions can be an informed discussion based on research and evidence. I'll share a few slides from our benchmark reports that show average overall costs for workers' compensation claims over time, as well as medical costs. I'll show a few slides on how provider choice regulations vary across states, and a few slides showing prescription payments per claim and how those numbers compare with other states. And let me share my slides here. Of all workers' compensation claims, 75 to 80% of them might receive only medical benefits with no lost time. So these slides show claims that receive both medical and wage replacement benefits, as they represent the majority of claims. And you can see my slides now?
Yes, we can see it.
Okay.
Yep.
Super. This slide shows the trend of the average cost per claim for both medical and indemnity benefits paid. And the lines are trends for 4 different maturities for claims. For example, the bottom line shows the average cost per claim at 12 months at each of the years shown. So for the first point of on the left-hand side for the bottom line, those are claims with injuries in 2000 as of 12 months later. And the yellow point directly above that is for claims in 2000 as of 24 months later. So they get more mature as the lines go up. You can see the general trend is increasing at 5 to 6% per year, but in the most recent 5 years, there was a decrease between 2019 and 2021, largely driven by some of the pandemic effect, followed by a more rapid increase. And this increase is seen in all of the components that make up overall costs: wage loss benefits and medical payments and benefit delivery expenses, things like medical cost containment expenses, and attorney involvement. So let's look at that same kind of chart for medical payments per claim. These payments include payments for professional services like physicians, chiropractors, and physical therapists, and payments for hospital services, both inpatient and outpatient. It includes payments for prescriptions and ambulatory surgery centers. And we see a very similar pattern of growth as we saw in overall cost. The most recent years saw increases in both prices and other components of medical costs. The prices are tied to the increase in the state average weekly wage, and in 2023, that was a 6% increase. So the fee schedule increased at the same rate. Sorry about that. Who selects the provider varies across states, and in the gray states, I apologize, I don't know what color they are on your state, but a gray state would be Montana. the employee selects the provider without any restrictions. In the yellow states, the employer has the selection. The dark green states, like Texas, have employee selection unless there's an approved managed care arrangement with the employer. In the light green states, like Pennsylvania, the employee elects from a list provided by the employer. And in this last group, the light green states, Pennsylvania is the only state that has a time limit. And there's a handful of states in the kind of army green color where the nuances are, it's nuanced enough that they're just in an other category. The next slides we'll look at describe prescription payments in Pennsylvania. And when we talk about prescriptions on these slides, we're talking about prescriptions that you would think of, you can either fill by mail order or things that you take to a brick and mortar store and get filled there. They're not things like injections or infusions. So there are 4 measures on this slide. The large chart on the left shows the average prescription cost per claim at 3 maturities and the trend. And you can see the effect of House Bill 1846 that changed the rules governing physician dispensing of drugs. And there's been an increase in recent years. Let's look at the 3 charts on the right. So this is, the left one is, remember, is the prescription per claim, because the claim is the unit of analysis in our studies here. On the right-hand side, from the top down, it's the average payment per prescription at the top, and you can see there's been an increase in the most recent years. The middle chart shows the average number of prescriptions per claim that had a prescription, and that's been pretty stable, not much difference, a little bit of a decrease. And finally, the percentage of claims that had a prescription. And you can see that was over 60%, and it's decreased to about 40%. That's a relatively large drop. So we don't examine the overall dollar spend on prescriptions per year, but you can see how the increase in the larger chart on the left-hand side would be muted by the decrease in the percentage of claims with prescriptions if you looked at that overall information. On this chart, we're looking at how does Pennsylvania compare with other states for those 4 measures. We see that the percent of claims with the prescription on the upper right is typical, but all the other measures, Pennsylvania is on the higher side. We looked at what might be driving this, and we found that 55% of all prescription drug payments were for dermatological agents. Those are topical creams or ointments or gels that are applied directly to the area. And what we're looking at here is the percentage of payments for dermatologic agents, how that compares in Pennsylvania to other states. So this is a percentage of overall payments for drugs. And in Pennsylvania, you can see it's right around 55%. The stacked bars represent whether it's physician dispensed in the yellow or pharmacy dispensed in the dark blue. And there are a few states where there is no physician dispensing, and those are in the dotted white bars. And finally, we looked at how has the claim payment for dermatologic agents changed over time. This is the most recent chart you'll see here is the per claim payment for those dermatologic agents in the most recent year that we have. You can see Pennsylvania is a little bit over $500, and the arrows on the top represent an increase or a decrease from the same measurement 2 years prior to that. So you can see some states went up and some states went down. And states vary in regulation in this area, including drug formularies, pharmacy choice laws, or price caps on these topical drugs. I think you also received documents from us, and they're referencing studies. If any of those are needed by the committee, just let me know, and I'll be happy to provide those. Thank you for your time.
Thank you. It was actually very eye-opening. Thank you very much. Any questions on the data? Go ahead, Barb. We have Representative Gleim here would like to ask a question.
I'm going to go back to this slide that says Pennsylvania total costs per claim increased rapidly after 2021 following the decrease. But when I go back to 2017, it looks like we were on a trend of increase, and then COVID hit. And then after COVID was over, we just continued on that trend. So I'm wondering what happened, or if anything, back in 2017.
So the overall cost, much of the cost in Pennsylvania is driven by wages. It's on the indemnity side. So you're correct that there was a bit of a disruption in the trend by COVID. And Pennsylvania is not the only state where there was a disruption in a trend that shows a little bit of a dip there. It's questionable whether that would have continued or flattened out again.
Thank you.
Welcome.
Rep. Dorsey.
Yeah, just a curiosity question, really. So in my time in the legislature, I've learned, I would say, a little bit about PBMs, pharmacy benefit managers. I just want to ask, just out of curiosity, this sharp increase, could any of it be steering these workers' comp patients to more expensive branded drugs where a cheaper generic would be an alternative?
That's a good question, and I don't have at my fingertips the difference between brand and generic between over time. How has that changed? But I can look at that and get back to the committee.
So looking at the data here a little bit on 22-23, I'm just curious if maybe a venue change by the Supreme Court has any kind of impact on increases. I don't think you can comment on that, Miss.
No.
Yeah, but it just kind of thinking back when the Supreme Court changed it, and then you see an uptick. I wonder if that has a impact potentially on it. Anyway, thank you. If we have any questions, just hang on. We'll come back to you. But thank you very much for the presentations. Next up is Mr. Dombrowski and Mr. Moore. Yep.
Since 1985. I want to jump back for a moment. I've seen in my own practice, particularly in southeastern PA, an increase that fits in well with her statistics in terms of increase with respect to prescription expenses. And for me, it was eye-opening because before this, I had my own impressions but couldn't put a number on it. But to see the numbers and the metrics that correspond to my experience, I think it was very eye-opening for myself as a practitioner. The purpose, however, for me today and Steve is to share with you several workers' compensation cases and decisions that may be of your interest. Let me go to the first case. And the first case may actually tie in with my last comment in the statistics. In that case, and the topic is counsel fees on medical expense. Traditionally, the way a claimant's attorney was paid is they had a contingent fee agreement of 20% with respect to the wage loss benefits that a claimant would be awarded or receive in a workers' compensation claim. In Nevis, an attorney had a fee agreement with his client of 20% not only of indemnity, but also medical. The statute, section 422, defines amount awarded. The Commonwealth Court decided that amount awarded includes not only wage loss, but also medical. Why is this significant? If the rule now is if an attorney has a fee agreement that provides for both 20% on medical and indemnity, you have in essence created a situation where the attorney is incentivized to potentially direct the individual to practitioners who treat more, who provide more costly treatment, more prescriptions. Your comment, for instance, generic, is Your comment, for instance, with respect to generic is when you see attorneys and doctors who are more sophisticated, those types of doctors, they'll specifically indicate that they don't want generic, the person has to have X. Some, not all. What you see in Nevis is a decision. Let me provide an example for you. If I'm an injured worker and I'm having a lumbar fusion, there's apportionment now that the carrier has to direct a medical payment 80% to the provider, meaning the provider is receiving 20% less for what they're doing for their work performed, and 20% is directed to the attorney. So for illustration purposes, if an injured worker has the misfortune of undergoing a lumbar fusion and the bill to be paid is $100,000 for undergoing a specialized procedure, the medical providers are receiving 80% or $80,000, and the attorney is receiving $20,000 for the individual undergoing that. For every prescription, for every doctor visit, every PT visit, any hospitalization stay, under Nevis, if an attorney has a fee agreement that provides for 20% of medical, the attorney receives 20% of that expense. I don't think this, I'll say in my own practice, I don't see injured workers recuperating more quickly where their attorney's receiving 20% of medical expense. What I do see, not universally, but what I do see in those cases where there is such a fee agreement, I see higher prescription costs and treatment and duration of treatment. In Pennsylvania, not all the attorneys have a fee agreement. Southeastern Pennsylvania, you see a higher rate of attorneys who have a fee agreement on 20% of medical and indemnity. The rest of the state is a little bit of a mix, less so. Steve and Paul may be able to describe that better, their own take on that. But the point is, I think if Section 442 was amended to specify that it is indemnity only, the amount awarded, I think that could be a potential fix to this circumstance. Steve?
So, real quick on that, do you see less healthcare participation in these cases? So if I'm a health system and I know if I have a workers' comp case in front of me, I'm going to get 80%. Right? Like there's kind of a disincentive for a doctor or a provider to want to carry those cases.
One of the claimant's attorneys that I had a conversation with, who's, I would say, a thought leader in Philadelphia, he made a comment to me. He does not take 20% on medical, and he has a significant practice. And he told me the reason is that he does not want to have limited access to care, being he doesn't necessarily want the person not to be able to go to Temple, Jeff, Penn, which many people think are the leading hospitals in Philadelphia. Mm-hmm. And that's the reason he doesn't do it with his cases. In terms of the providers, I don't know if the providers are fully in tune with what is happening. And the reason why is, what I see more so is, on the cases that have the 20% medical fee, I tend to see physicians who I would say are more aligned with the attorneys, and there's a group, sort of an informal referral relationship that you see of sorts. In terms of the larger institutions like Penn, Jeff, and Temple, I'm not sure what their level of awareness is of this until the billing comes.
Gotcha. So generally, the attorneys who are doing the 20% have an entity they normally work with that understand the arrangement, or they work with groups more so than others.
I don't have direct knowledge of their relationships other than what I see.
Right.
And what I tend to see is a cluster of a couple groups who cross-referral each other.
Okay. All right. Thank you.
And if I can add to that, there's already some lack of access in Pennsylvania. There are groups of providers who simply do not take workers' compensation, injured
Mike, yeah, make sure it's on and just pull it close.
The green light is on.
There you go, perfect.
Okay, perfect. So there's already a minor access to care in Pennsylvania. There are groups of healthcare providers who will not take workers' compensation claims and the injured workers to provide treatment. So what happens in the scenario where, as Attorney Dombrowski has indicated, the knowledge base on the provider starts to grow. The hospitals start to realize they're getting 80 cents on the dollar. Does access to care continue to diminish? Staying within the theme of why Attorney Dombrowski and I are here, you've heard a lot of high-level information, an awful lot of statistics. Neil and I bring some ground-level views to the chamber today. And one of the things that Neil and I talked about were what cases, what is out there, what indicates something that may be brought to the attention of this panel, obvious targets for change, obvious targets for review, obvious targets for potential revision of the statute. So with regard to a relatively new case, a 2025 case involving cannabinoid oil or CBD oil and an employer's responsibility to make payment, an injured worker goes to see a medical provider, receives some opioid medication, ultimately decides that he wants to use CBD oil, gets a prescription from the provider, and then submits the cost of the prescription to his employer for reimbursement. The employer takes the position, in essence, it's not a pharmaceutical and we're not going to make reimbursement to you. The case goes into litigation, goes to the Supreme Court, and the Supreme Court ultimately decides that CBD oil falls within a term in the Act, medicines and supplies, and mandates that reimbursement be made. In addition, the second portion of the holding is that the cost containment provision of the Act does not apply to the claimant because he's a consumer and he is not a medical provider. And I put a quote from the Supreme Court in my submission, and I'll quote, "The court reiterates our conclusion that any item that is part of a healthcare provider's treatment plan falls within the purview of the broad encompassing phrase medicine and supplies." So what information, what is clarified by the Supreme Court? Because quite frankly, from a street level view, I look at this decision and think to myself, there are more questions now than answers. So if you can get a prescription for what's the a new Lazy Boy recliner because my back is bothering me, and perhaps I would like the leather one because the cost containment provisions don't apply. I want one of these new bendy Tempur-Pedic mattresses that heat and cool. We see them on TV, and I'm married, so I want the king-size one as well. So I go over to the local sheets, and they have, I don't know what those silly little things are. They hang there, help with your vigor. They help rebuild chondroitin and glucosamine. You get a prescription for that from your doctor. You can go buy that off the shelf. And because there's no cost containment, you can pay whatever you want. So from a ground level view, I see this Schmidt versus Schmidt case as one that raises many, many questions and really doesn't provide many answers.
So it's fascinating because I think everybody sees the stores with like the bright neon lights that say CBD oil, right?
Right.
They also sell kratom. I'm not sure if there's a doctor out there that's going to prescribe kratom, but nonetheless, under this, I would assume if a doctor prescribed kratom to someone for workers' comp injury, might be covered, as crazy as that sounds.
Certainly the word any, as used by the Supreme Court, means any.
Yeah. Representative Glenn.
So you mentioned that there were some providers that won't cover workers' comp in the industry there. I was just wondering, are you seeing a difference between risk level jobs and low risk level jobs? So is there a distinction between, we'll cover workers' comp for low risk, but we're not going to cover workers' comp for the high risk?
What I see in my practice is the individuals, the physicians who do not treat workers' compensation claimants, it's an across-the-board decision. So people are boxed out. Okay, thank you. Neil?
Next case is the topic of compensability for medical marijuana expense. And this is a trend following what Steve referenced. The name of the case is Appel and Fagley. The Commonwealth Court has held that if an injured worker has been prescribed medical marijuana, which is found reasonable and necessary for the work injury, the carrier is liable to reimburse the injured worker for the medical marijuana expense. Medical marijuana is not subject to the cost containment caps. Therefore, the carrier is obligated to reimburse 100% for whatever medical marijuana that is prescribed for the work injury. The Medical Marijuana Act came out and they identified 17 conditions, one of which is neuropathic pain. And you see that in the workers' compensation arena in terms of a condition that this may be prescribed for. When they came out with the medical marijuana, if I could say that once, the Medical Marijuana Act, they specifically indicated to the General Assembly that insurance carriers would not be liable to pay for it. This holding basically sidesteps the specific intention of the Commonwealth in terms of enacting the Medical Marijuana Act. This drives up medical costs. When someone gets medical marijuana, you're really not acting where you're giving a script and they're telling you exactly how many milligrams you're getting and the like. It's sort of an interaction between the person at the dispensary behind the counter and the consumer. So is the individual taking a little? Is he taking a lot? It's sort of open range. Likewise, it increases the carrier cost relative to what the individual is getting. It's not just a factor with respect to medical cost. It also affects wage loss. If an employer is in an attention-sensitive or safety-sensitive position, and an individual's recovering from work, and say they have a warehouse and they're running forklifts, they may have concern about bringing someone back who's using medical marijuana to be in an environment where forklifts are going back and forth rapidly, where a new risk of injury to him or someone else may occur. In addition, many employers have substance policies that prohibit the use of that substance or being under the influence of such substance in the workplace. So this is an obstacle to the individual returning back to work. If an employer wants to present evidence that there's other work out there you could be doing with somewhere else, in the litigation arena, a claimant will argue that I am ill-suited for these other positions because those other employers may not consider me. I have cognitive limitations by virtue of the medical marijuana that I'm taking. Therefore, I couldn't get that job. I couldn't work with a cash register and make change with money because I'm under the influence of this and I may make mistakes. The other argument that they'll make is that the employer may have policies, these alternative employers, they may have drug and or substance policies, meaning they wouldn't even consider me. End result, it serves to enable an individual who's desirous of not returning to the workforce to extend it, increasing wage loss as well as medical costs.
Would expanding marijuana to recreational have an impact on workers' compensation? Have you seen that from other states, or is it mostly around this medical marijuana?
It's a good question. I think
I don't know if you've seen data or anything.
Most of the people, many of the people we represent have policies and procedures that prohibit use of marijuana to start with. In terms of policies and procedures, many prohibit use of recreational marijuana. Where we see that come up the most is where an individual is injured, and when they're injured, many employers have drug testing requirements, and then they see that the person is pop hot for marijuana, and that's where they become aware of it. And with respect to the medical testing that is done, which is typically urine, you can't tell whether that's the proximate cause of the individual's injury or not. It only shows use relative to, say, 36, 48 hours relative to the event. So I think in terms of recreational, that's really where I see it. Steve, that was complex. I'll let you handle that one.
Yeah.
I agree with Neil. Generally, with regard to the recreational use of marijuana, it is a post-drug screen that turns up the usage, which then can lead to termination from employment with a dispute over whether or not an individual is entitled to indemnity benefits. Medical benefits would usually be payable in the event the individual was actually injured and needed ongoing medical treatment.
So,
any questions
but,
for Neil?
Yeah, but one of the problems with marijuana too is it stays in your system longer.
Right.
So there's no real, like, you don't know if it was like a month prior. So it's tough, right?
If you have blood serum contemporaneous with the event, I believe you're able to ascertain THC levels using blood serum. But most of the testing, I'm told, at occupational medical centers is usually urine, and at hospitals, usually I see it being urine, although in the case of Department of Transportation cases, I've seen more blood serum as being the test, particularly if there's a death.
Okay.
And
no, go ahead.
certainly, there is the hiring of a toxicologist to look at the information to see if they can work backwards to provide you with certain levels.
Right.
But that's generally very difficult to do with a urine screen.
Yeah, this is probably an area we're going to continue to struggle with as obviously we have medical marijuana out there, but as we debate this legalization, how is that utilized in our state with testing and verification? I mean, it's an ongoing thing we have to be very cognizant of, particularly since the Supreme Court has ignored one statute that says you can't use this and found a way to enter it in. Alex, you want to comment on that?
I would just note, medical marijuana is unique in that not only is it legal in Pennsylvania, but the Act 16, which legalized medical marijuana, provides specific protections for employees where they can't be discriminated against solely based on their status as a card holder. So they enjoy protections. That becomes complicated for employers, especially in safety-sensitive industries, where the current law is just very ambiguous and confusing when medical marijuana use can be legitimately factored into an employment decision because there is a safety concern. So you have employers worried that they're going to get sued if they tell someone, well, this is for a school bus driver or a forklift operator, maybe this isn't the best position for you. There's exposure to liability. Recreational, I think, I've seen studies that indicate both sides make the same, opposite claims. I've seen studies that indicate that the rate of workplace accidents increase when recreational marijuana is legalized because of just the potential for impairment. The key, however, presumably a recreational marijuana bill would not protect the right of individuals to use marijuana or be impaired on the workplace, just like alcohol is legal, but an employer can say you can't be drunk at work. So the devil would be in the details to the extent legalizing recreational, I think, would impact workers' compensation and kind of broader workplace safety.
May I offer something? In the spirit of conversation, my recollection of the medical marijuana decision was, or is, the court made took a very unique position, because Neil's right, the statute's very explicit. Insurers are not required to cover this. Court said there's a distinction between coverage and reimbursement. That was the line that they took. And so what that means is that there's no coverage per se, but that if someone were to get medical marijuana, they would, in theory, they could get a receipt for it, submit the receipt to their workers' comp insurer, and seek reimbursement. That was, and I'll defer to the practitioners on this, but that was my recollection. Was they made a the statute when it was enacted was very clear. And there's no, and that was true for workers' comp insurance. That was true for auto, for the medical side. That was true for health insurance. The court said, yeah, that's a little different than reimbursement, and that was the distinction that I think they made.
Thank you, Mr. Chairman. Just a moment of color commentary on this. This case involved a workers' compensation injured workers attorney, sole practitioner with an occasional helper, suing his own law firm in order to get reimbursement from his law firm's insurance company for this type of modality. And this is why it's important to bring that out. What the Supreme Court did was take a very academic approach to the issue, and I could use other words, but let's call it academic. What they failed to do was defer the matter to the legislature for hearings, for testimony, for information from all sides of the issue so that a proper law, rule, or regulation could be crafted. Mr. Schmidt, who I know well, can decide when to drive a car, when to write a brief, when to argue in court, or when not to, if he's not operating on all 8 cylinders. The problem here is this has widespread effect for Pennsylvania employers, and as you've heard, the problems can be significant.
I wonder if Mr. Schmidt still is with his law firm.
He is.
Wow.
It's his own firm. Small firm.
He sued himself?
He sued his law firm's insurance
That's
carrier.
Wow.
Whether that carrier rewrote him or not,
Right.
I don't know.
Right. That's, thank you. All right. Please continue. Thank you.
So one of the cases that Neil and I talked about and put on the list has already been discussed. I thought Mr. Greer did a very nice job outlining the federated insurance matter, the Red Book matter. So let me just give a few details, from my observation. So average wholesale price, is it not a term of art within the industry? That's an argument that is flying around, but I certainly know what the term wholesale means. Wholesale means wholesale. And certainly the prescription bill that was submitted for generic prescriptions was over $70,000 with a claim that was the average wholesale price. The carrier submitted contrary evidence indicating the average wholesale price was a little over $1,500, so almost $70,000 apart. Went into fee review. The fee review officer ordered a payment of $72,500 approximately owed to the pharmacy. So that's really the construct of the case. Mr. Greer outlined some of the positions, some of the high-level discussions. I'm going to bring it right down to a consumer's perspective. So wholesale means wholesale. And I see some of these prescription bills in my practice, and they are just tremendous per month. And this is just a made-up number. So $400 a month for 30-day supply of pills. And then I wander over to the local CVS, and I take one of those little yellow cards off the counter, the Good RX card, which I can use without using my own personal insurance. I hand it to the pharmacist along with a $20 bill, and I get the same amount of pills, the same prescription. So if one section, that $400, that is supposed to represent a wholesale price, and I suppose you can try and spin it up with average wholesale price, but if $400 is wholesale and $10 is retail, there's an issue. Certainly one that is subject to, I believe, legislative scrutiny and legislative review. So there's a case that is not on the list, and I thought as we started to flow through some of the cost containment provisions, how do we keep costs down? There's a case involving a pharmacy that is currently pending a la carte before the Supreme Court. It's an interesting case. A utilization review was conducted years ago. The utilization review found medications to be unreasonable. The pharmacy kept submitting bills post the utilization review, and eventually, by accident, the compensation carrier made payment. Upon realizing the error, asked for the money back. The pharmacy declined to give the money back. The matter went before a workers' compensation judge who ordered reimbursement. The pharmacy has litigated that case through a number of turns, and it's now a pending aliquotter. The Pennsylvania Commonwealth Court, in a 2-to-1 split decision, indicated there's no basis in the act to allow the carrier to mandate reimbursement. One of the Commonwealth Court judges said, well, of course, without a means of ordering reimbursement, isn't the act then just a nullity? There's another competing case from the Pennsylvania Superior Court which mandated reimbursement in a somewhat different but somewhat similar scenario, but giving teeth to a workers' compensation judge to mandate reimbursement. So at this point, it's pending aliquotter, but one of the seeds that I am looking to bring before you today is the claimant and claimant's dependents have the ability under the workers' compensation statute to enter judgment against an employer and an insurance carrier to mandate payment. From the other perspective, the employer and the insurance company do not have any basis under the act per the Commonwealth Court's decision to mandate reimbursement from the pharmacy who submitted bills after their medications were deemed unreasonable and necessary, were paid, and who are now simply refusing to make reimbursement. I can certainly provide additional information post-hearing if there's an interest in that. Please just let me know and I'll be glad to set that forth. The last case that Neil Dombrowski and I discussed, it might be an old one. You'll have to excuse my voice. It dates back to 2018. By anticipation, everyone here will recognize the name Whitmoyer versus Mountain Creamery Meats. The Supreme Court in that case took a look at Section 319 of the Act and removed the employer's ability to take a credit, take subrogation against future medical expenses after a plaintiff or plaintiff claimant received a third-party recovery in excess of the then existing subrogate right to reimbursement. So what has happened over time, I see this from time to time in my practice, we have a plaintiff, also a claimant, who has litigated a case in civil court, has put evidence in at the trial court level that I have pain and suffering and I have loss of wages, but I also have future medical expenses and I want compensated for that, and then gets an award. A perfect example, one in the back of my mind, there's a $6 million pot of money that the plaintiff received in a civil case that arose from a workers' compensation case. Under Whitmoyer, the carrier continues to make payment on those medical expenses when the claimant has been compensated in the civil case for those medical expenses. So I don't know if we call it double dipping or a double recovery, but certainly as those medical benefits continue to be paid by the workers' compensation insurers, continues to keep the cost of that claim high. And when you magnify that across all of those similar claims across the Commonwealth of Pennsylvania, it's adding a level of costs that should be borne by the third-party resolution, those monies that are being held by that claimant plaintiff.
Tying back to Nevis, in Nevis, the court reviewed the phrase amount awarded. They interpreted it then to include medical and indemnity. In Whitmoyer, they interpreted, I believe, the word compensation to be limited only to wage loss. It doesn't align.
The terminology that was used in Whitmoyer was installments of compensation. So an installment of compensation would in essence be a biweekly or weekly workers' compensation indemnity check. So I suppose a periodic payment of medical expenses, at least according to the Supreme Court, would not be an installment. An installment, from my perspective, if you make periodic payments, I would suggest that is an installment.
Right. Fascinating. I'm sure we'll come back to some of this stuff, but I want to make sure we get our last testifier in. And Mr. Fires, the floor is yours.
Thank you, Chairman, and thank you, representatives. It's a pleasure to be here. A little bit about me. Interestingly, I was the law clerk for the House Energy and Commerce Committee in Washington while I was a law student. So I'm really familiar with how difficult this process can be. I appreciate your taking a look at this, and I thank you for your service to Pennsylvanians. It's very meaningful.
Thank you.
I've been a practicing workers' compensation lawyer for 35 years and a lawyer for almost 40. I'm a defense lawyer. It's all I've ever been, and I've always worked with the same people, and we founded our own firm. Our firm in Pennsylvania has the privilege of representing our Commonwealth's largest employers and small and medium-sized ones as well, along with almost every workers' compensation carrier from A to Z, including the third-party administrators. So we have been in the trenches on a lot of these issues for many decades. And there's a lot of institutional knowledge for the people who preceded us and who are no longer practicing at our firm. When I started out 35 years ago, I have to say nothing much scares me, but I would go to see some of my clients, and safety hygiene was simply not a priority in those days. Yes, it has changed significantly, and we still make things in this state. We still have jobs in this state where people have a propensity to get hurt. But it is unbelievably safer in my own anecdotal experience, and safety priority and safety penalties for those who don't promote safety in all of these employers, it's significant. So that's a favorable thing, and that I think helps lead to why workers' comp is, as you've heard, stable. But when we're here to talk about the cost drivers here, and if you look at my notes on these 6 items that I'll be talking about, it's one thing really. This is all medical. It's just all medical. We applaud when our workers make a little bit more money, that's fine. The comp rate is tied to what they make, so that inches up, that's fine. This is all related to abusive medical issues. I want to thank my colleagues for teeing up all these issues so effectively. I'm not going to repeat what you've heard, but I'll touch on a couple of points that I would like you to consider as you deliberate some of these important questions. As was pointed out, some of our southern neighbors are taking our jobs, they're taking our employers, and as Alex said so well, you need more taxpayers. More taxpayers solves a lot of problems. As one of my mentors told me, money solves all problems, but that will come through additional employers in our Commonwealth. Starting with number 1, what I see with my clients is they have injured workers who continually renew prescriptions or modalities, durable medical equipment, continually. They don't go to the doctor. The prescriptions aren't rewritten. And what's going on in the insurance industry today, in the claims industry, is it's very hard to find someone who wants to go into that line of work. The pool is incredibly shrunken. It's putting incredible stress on who's there, and it's driving up costs to really chase all of this down. A very simple adjustment to the act would be to require periodic doctor visits to support prescriptions of both medications and modalities, and of course, written prescriptions to keep them going. Without that, it makes it very difficult for our clients to fight without hiring me or engaging in expensive litigation, needless litigation, over something so obvious. If I want to get a refill, my doctor, an intelligent person, will ask me to come in. There should be the same thing in workers' compensation. Number 2, the Red Book pricing. It's being looked into. It was addressed well by my colleagues. Pennsylvania, you saw where our number was in terms of cost. There must be a very simple cost structure for reimbursement in Pennsylvania, just like there is if you're a non-workers' compensation individual needing medical care. There are cost structures. Pennsylvania lacks that. That's something that should be fixed by the Bureau. Generic drug usage. I find this the most interesting because I feel I'm an individual with a strong health insurance plan. I'm very blessed, and good medical care from my team of physicians, but my statin is generic, my acid prevention medication is generic, my gout medication is generic. I could go on, but you get the point. Why there isn't a mandate for generic medications for injured workers is a mystery to me. If brand necessary is required for the health of the injured worker, we would all agree that's fine. But typically what you see is this is one more way, especially with the 20% on medicals, this is one more way to drain our system of funds and put them in the wrong pockets. Brand medication is as effective, generic medication is as effective as brand. I can't quote the statistic, I'm sure it's in the 90s. Let's move on. Extending the notice of compensation payable term from 90 to 180 days or even 365 days. The minute we lose medical control is when you start gaining expense. Administrative expense for the carriers and TPAs and self-insured employers, legal expense for people like me, all kinds of other vendor expense. Independent medical examination industrial complex. When I started out, it was $1,000 for an exam. It's now $7,500 for an exam. And sometimes you need 2, maybe even 3, depending on the complexity of the injury. If there was medical control with quality panels overseen by our employers or the carriers, you would have none of that. Administrative costs of the type I'm describing would be substantially reduced. But most importantly, and I want to emphasize this, I have seen thousands of cases across the course of my career. No one who's been out on disability for a year or more comes out of it the same person. Now, some people need to be. Some people are horrendously injured. Some people may never be able to work. But sometimes the injuries are career-altering, but not work-ending. These people need to get back to work for their psychological health, if for no other reason. But that's a big one. It really saddens me to see 2- and 3-year-old cases and what happens to these people. We shouldn't have that. One of the things medical control will help do is provide a framework to get these people back to work. For the amount of time that we have, they mostly go back to work. I submit that if you extend the time, you'll see more people back to work and a more productive Pennsylvania. The 20% fee on injured worker medical benefits is such an interesting thing, and I will comment on some of your points. It's a Philadelphia thing, or a 5-county Pennsylvania thing surrounding Philadelphia, I should say, without question. I know lots of injured worker attorneys who are too embarrassed to ask for it, and I know some judges who refuse to order it. It is controversial. It was driven largely by a few for the benefit of the many, but the many aren't even taking advantage of it as fully as they could. It's a bad plan because it is very hard to find a doctor who will accept workers' compensation payments on a good day, which are overall somewhat less than retail. But if you take 20% off of that, they either won't take the case, or they'll overtreat, or overprescribe. That's what they'll do to make up for it. I remember one time a physician told me that he was being really harmed by some of the reform proposals, and he joked, half-joked, I may have to go get a diesel Mercedes instead of a gas Mercedes to save money. That shouldn't be part of the discussion. The money should go where it's needed. I want to end with the fact that there are a lot of pharmacies that work in conjunction with law firms and providers, which leads to the explosion of compound cream use. That absolutely has to be separated and stopped. Let me conclude by saying that Pennsylvania employers, in my experience, want to do right by their injured workers, in part because they're mostly good people, but also in part because that's good business. It's smart business. To find a new young person and train them up and they may leave after 6 months, the situation out there is very challenging, but they don't want to be taken advantage of. Thank you for your time.
Yeah, I want to hit on your last point of the compound creams. So my wife's a state licensed drug dealer. She's a pharmacist by trade. I enjoy saying state licensed drug dealer. Kind of backfired. It's a pointless story, but it kind of backfired because my middle child was in elementary school and forgot the state license and told his teacher, my mom's a drug dealer.
Okay.
She hates it. I think it's hysterical. So don't tell her I am still using that phrase. But the compounding is interesting because most of the creams you can get already made.
Voltaren, for example.
Right. So you don't really need to compound much of anything. It's a very specialized field. My wife has spent a career in retail. working for the biggest of the big companies and small grocery stores, but like she doesn't compound. Like, it's not a normal process in the world of pharmacy. So when we look at the data on the cost that was provided earlier, you see a direct results of dermatology as a huge cost driver, and one would think the compounds is being used for the dermatology aspect, correct?
It is being used for the dermatology aspect in lieu of the pre-manufactured, pre-made, pre-dispensed, popularly available products. You have pharmacists creating these compounds simply because there's no price cap. And because there's no price cap, it can be up to 1,000 times more expensive than a commonly available product. That's what's driving this. It's a desire to make your income in an uncontrolled way that's still maybe even healthful in some instances, although there's plenty of data that says not all of this is, but there are commercially available products designed to do the same thing. And that is what needs to be explored. You didn't have this previously, but there's literally no data showing an explosion of recovery due to the availability of custom-made compound creams made for the individual. There's no data on that. They'll never get data on that.
Right. And again, going back to your generic versus brand name, it's similar within the creams, right? Your simple generic would be it's already made, it's already manufactured. You have it, here it is, versus a compound, which would be a not even a brand name, it would be a specialized, like biosimilar in the world of pharmaceuticals, like a highly expensive GLP-1, right? This big cost to do that.
That's correct, Mr. Chairman. And while I'm not a doctor, and there may be certain cases where it's appropriate, but the broad application of that medical strategy is not appropriate for most of these cases. We're talking about it being used in very basic injury scenarios.
Right. Can you give us some examples? I would think of dermatology like serious burns. Like, what are we talking about when we talk about kind of dermatology injuries?
Well, it's actually not a dermatology injury. It could be a bone injury. It could be a muscle injury. It could be a nerve injury. And the way Voltaren works, for example, you apply it topically on the painful area of your body, and it's an analgesic. It does reduce the pain. I've used it myself when I hurt my ankle. It's an effective thing to use. You don't use it forever because, like anything else, if you ever use it, it can have side effects and be damaging. This isn't for burns. This isn't for scars. This is for muscle pain, bone pain, nerve pain. It's meant to dull the pain.
Gotcha. So when we talk about, to clarify, when we talk about dermatology, we're talking about pain.
Skin-applied medications.
Skin-applied medication.
But not necessarily for the dermatologic purpose.
Right. Gotcha. Okay. Fascinating. Question? Chad? Representative Rossi, Representative Cooper, anybody questions virtually? Just double checking. None. Okay. So in general, we're always kind of pushing up against, this is heavily litigated. So we're constantly, as they play whack-a-mole with court cases, but it's constantly getting litigated and the ball's constantly moving. And from what I hear, we have court rulings that may be in conflict with each other based on previously and lining it up. And then we have to be careful and watchful for new drugs on the market, so to speak, medical marijuana, potential recreational marijuana having direct impact on this area's cost. But the number one driver really in Pennsylvania is prescription drugs. It is the number one issue we have to look at to really get costs under control and make it more consistent both for the employer and the employee moving forward.
I would agree with that. And the purpose of a legislature is to consider all of these issues
right.
and come up with the best solution, both political and otherwise, serving the state. I don't mean this in any way complicates my respect for the Supreme Court or the Commonwealth Court, but they look at these issues very much in a vacuum and it applies to very specific cases. That's why why I gave you a little bit of commentary on the Smith case. I thought it was important to know that there wasn't a broad investigation of the impacts. How could there be? That's not this body.
Right.
I think that viewing all of these legislatively will be best for the Commonwealth.
Right. It seems like in a lot of these cases, the court generally is playing legislature, but they don't have the insight. They're not doing hearings. They're not flowing through what could happen. Representative Gleim here is phenomenal at going down the rabbit hole on what if this happens, what if this happens. Like, she's phenomenal at it, thinking outside. It seems to me they're not thinking. And I'll go back to the case of CBD oil. Where does it end? Like, in our discussions, I know when we hit caucus or on the floor on the debate, hey, if I got this bill, what do you guys think? My colleagues are coming back at me. What if, right? We have that expertise and that thought process versus that individual. So we don't have that abuse of opening the door and have the unintended consequence. I'm fairly certain our judiciary is not thinking, you should give kratom to people, right? But in reality, their ruling could result in some really crazy things happening. Yes. And they should really be maybe a little more insightful and say, hey, you guys need to go look at this a little bit more versus giving a blanket waiver. Yeah. Representative Cooper, you have your hand up. Go ahead. Sorry, Rossi. Representative Rossi.
Thank you. I just had a question about the individuals and who reaches out to them to encourage them to go back to work, because sometimes the employer, isn't really seeing them. They're not at work, so they don't know what kind of condition they're in or what their state of mind is. Do we have anybody that reaches out to them and encourages them? Because I know sometimes they're afraid to go back to work and it's hard the first couple weeks, and then it gets a lot better and their mind frame gets better. What's the process with that?
So ordinarily, it's sort of a mix. The individual often will receive a release from their treating physician or from an independent medical examiner, which would be a physician selected by the carrier who performs an examination but not playing a treating role. After you receive a release, the statute has, I almost call it the Miranda rights at workers' comp. You have to issue an LIBC 757, which is a noticeability return to work. And that form tells the injured worker that your condition has improved, you will have an obligation to look for work, and this often starts the process. The employer who's monitoring the claim will often be looking for the recovery process, and when they receive the notification, either an IME or a treating doctor release, they may reach out to the individual communicating that there's modified work available. If the person's still under a restriction, they issue what's known as a job offer letter that meets all the statutory and case law requirements, or they'll issue a letter to the injured worker saying that you've been released to work full duty and we have a job for you. That's typically the process and sort of what I see between the employer, the claims adjuster, and the injured worker.
Okay, great. And then if the person comes back to work and it's not going well and they're having more complications than they thought, what's the process when that occurs?
It depends. If the person is acting in good faith, the employer sometime will not pursue it, or they'll get an independent medical examination to get a second eyes on the circumstance. For example, if the treating physician releases the person comes back to work and they perceive the person as not acting in good faith, maybe playing games, they might arrange an independent medical examination to get a fresh set of eyes on the person. And if they feel that the person's bona fide, they might not pursue it, and that the person would continue to receive workers' compensation benefits. If the employer believes that the person is indeed playing games and can do the job, the employer may initiate a petition, suspension or modification petition, to ask a workers' compensation judge to adjudicate whether or not this person can pursue the work that's being offered.
Okay, thank you.
Thank you. Representative Gleim?
Yeah, I just had one last question about the panel that we had been talking about. You know, during COVID, it was considered a sickness. It wasn't necessarily something that was an injury in workers' comp. But I remember during COVID that in some instances, because it was a disease that was contracted, maybe somebody brought COVID onto the job site and then everybody else ended up getting it. There were some people that thought that was a workers' comp injury. Could you speak to sicknesses within the workers' comp reimbursements?
Yes, it absolutely has the potential to be an injury because workers' comp is a default statute. And if you develop sickness or physical injury or mental health injury at work, there's the potential that it would be found compensable. After COVID settled down, and sadly there were a number of deaths, and there were some survivors who had enormous hospital bills and a lot of time out of work, there were a slew of workers' compensation cases brought, and they were almost all defended. Many were also settled. Those where there were deaths were largely settled because a death is a very sad thing to argue against. Can you hear me now? Can you hear me now? I apologize. Do you like me to repeat anything? All right. A lot of the death cases were settled because a death case is a very difficult case to win. The act is meant to be humanitarian, and it's a difficult case when there are widows and surviving children. But the central argument about proving a COVID case as being work-related is this. You have to be able to show within reasonable medical certainty that the speck of virus entered the body at the workplace versus anywhere else. Anywhere else. And we hear all kinds of testimony about people saying, I never left my house except when I went to work. I rode the subway to work in a dive suit. I'm exaggerating, but this is the kind of thing that we would hear. And of course, you know, the person who worked next to them was coughing all the time and things of that nature. Now, that's colorful to hear, but it's still anecdotal. It's not scientific, and there's no scientist worth their salt who would say within reasonable medical certainty the speck of virus that entered your body happened at 3 in the afternoon on Tuesday, November 24th. It's impossible. That said, under the confines of a humanitarian act, some judges were sympathetic. There are always doctors who will say what the retaining attorney would like to hear from them. And you had some cases that were found compensable, and you had some cases that were settled. Scientifically, I personally believe that that's a very difficult case to prove. There are other sort of diseases that are more easily proven, but scientifically, that's a tough one to prove.
I agree, and but some of the employers I talked to with related to the panel that they offered through their insurance company didn't have docs on the panel that were specifically knowledgeable about this kind of communicable disease. So the employees wanted it added to the panel. Do you have anything to say about the nimbleness of an employer working with insurance companies to add docs to the panel in a timely manner when something like this occurs?
I would certainly agree with you, Representative, that in an international pandemic, there should be an infectious disease specialist added to the panel. I think a savvy employer or carrier would be spearheading that, but there was an awful lot going on then, and that was probably not the first thought to occur to them. But to answer it slightly differently, when the overuse of chiropractic services started to become a thing, one of the things I advised my clients, and many of them listened, was to add a chiropractor to the panel. So when you see something like that happening, you can always add to the panel. You can always take someone off the panel, perhaps to your detriment, or perhaps if they're not providing the service. But you also are looking at where your need really is. Your need tends to mostly be physical, musculoskeletal, neurologic, sometimes psychiatric. Infectious disease is rare. I think it's just far from what most people are thinking about, but it would have been best if someone with infectious disease experience was added to the panel at the time. Although, interestingly enough, it's not the type of thing where you could just get treatment by going to your infectious disease doctor. You were quarantined, you were segregated, hospitals didn't really know what to do. It was a very difficult time back then.
The one thought that I have is, and Paul, you might correct me or elaborate, is I think if you go to an OCMED center on the panel, I believe a panel can refer you to a specialist if you see someone who's on the panel. For instance, if you see an internist or an occupational medical doctor, if I'm not mistaken, they can refer you to a specialist, and they could refer you to an infectious disease expert or a pulmonary physician. I don't know if I believe I'm on safe ground on that.
Neil, you're absolutely right. The way the act is written, you can be referred to anyone off panel by someone on the panel, but the treatment has to be on panel unless the panel lacks the expertise. And if the panel lacks the expertise, which makes sense, you can then get it compensated off panel. But if you say go to an orthopedist on panel, you want a second opinion, you can go to an orthopedist off panel paid for by the carrier. But if the orthopedist prescribes surgery or any other treatment, that treatment must be provided by on panel, but only in the first 90 days. And that's the key that hopefully can be changed over time.
And not to belabor the point, but I do think that's a very important aspect of this discussion when we've discussed the panel and proposals to expand the panel. There is a misconception that if the panel does not have a doctor who specializes in your type of injury, a misconception that you're somehow forced to treat with a provider who's not qualified, which is not the case. It is the requirement is on the employer to maintain a panel that has the proper specialized providers, and if they don't, then the patient can treat off panel, and it is covered. If that's fair to say.
It is fair to say, and there's one more gotcha aspect to this that I'll just share and move on after that. You do have to sign a rights and responsibilities form when you're hired, and most employers are savvy enough to do that. You also have to sign a second one after you're injured. Now, some injuries don't lend themselves to being presented with a form for signing, and some people may decline to sign. But if you don't have both signed pieces of paper in your arsenal, you can't require them to treat with panel. Now, I understand getting it signed at the time of hire, maybe even annually. But when someone's injured, that's probably the last thing that they're thinking of, including the employer, who's mostly interested in getting them perhaps in an ambulance to a hospital. That's a really unfortunate part of the act that should also perhaps be looked at. You want to ask people to sign them manually as part of your electronic employee handbook thing, that's fine. But having to present them with something when they've just broken their leg and are waiting for the ambulance, it makes no sense.
If I may, just one last comment on the panel conversation. Typically, those panels are comprised of a network that has been quote unquote rented by the comp insurer from a health insurer. So in this area, it would be Capital Blue Cross or UPMC, down in the southeast it would be IBC. The point is those panels, therefore those networks, are robust, and they have to meet, excuse me, Department of Health and Insurance Department network adequacy standards. So just the way this will work is that IBC or Aetna or whomever else has to have a network that meets network adequacy standards that will be used by a comp carrier through the panel. They will access that network. So in the context of COVID, there may well have been, we were in uncharted territory. And while that was a quote unquote adequate network for the for the sake of COVID and what happened that no one was prepared for, it was, it was technically adequate, but it was practically inadequate. That may have been what happened there, because there just weren't enough infectious disease people within the adequate network.
Representative Record.
Thank you, Mr. Chairman. Just, I guess, a quick final question. I mean, we've had Kramer versus Kramer, but does anyone have the rights to Schmidt versus Schmidt? Just asking for a friend here. So, we've heard a lot here today about workers' comp and truly how our system here in Pennsylvania has an ample amount of opportunity for reforms to both help the employees and the employers. I guess the old question is, how do you eat an elephant? It's one bite at a time. And the first step is House Bill 1998, where we take a look at the panel. We see the benefits associated with the panel, where you have a team of physicians who know their trade, who know their specialization, and who are concerned with the patient and getting that patient fully recovered and back into the workforce. We hear stories of, today of individuals who might be, outside the 90 days going to, voodoo doctors that are prescribing, at the absolute worst, ineffective treatments, and in a lot of cases, ineffective treatments, and these treatments that might hinder the person from actually recovering and getting back into the workforce, where you have a person who is prescribing medical marijuana to a forklift driver whose job prohibits them from being high while doing it. So, when you have a panel of trained physicians and specialists whose job is to help that injured worker recover and get back into their job, that is the best case scenario for everybody involved. And as we heard, our businesses are looking, they have identified workers' comp coverage in Pennsylvania as a stumbling block. It is an impediment to locating here. It drives up their costs. And again, meanwhile, while the costs for the businesses and the employers are going up, the healthcare quality outside of the panel for the injured worker has the potential to severely decline, and there's less access available to them as well. So again, eliminating the 90-day requirement isn't the silver bullet, isn't going to solve all of these problems, but it's step number one in ensuring that, again, we have that threaded needle, right, where we can balance both cost containment and worker recovery. It allows the workers to be able to get the care they need to, as quickly and effectively as possible, return to the workforce at the lowest possible cost to the employer. So again, Mr. Chairman, I thank you today for assembling this great roundtable here, just to provide a little bit of some light on what might be one of the more challenging and dry components of law here in Pennsylvania. So thank you, sir.
Absolutely. I want to end with one more question. The Red Book issue. Is there a simple solution the department could do and implement today to get a fix on that without any legislative fix or the court? Simple question. Simple.
The department certainly had an extended period of time to mull this over, seeing as we're now well over a year since appeal was granted at the Supreme Court level. So what is a nationally recognized schedule of AWP as outlined by the Commonwealth Court? I'm not sure, but certainly insurance companies, the Aetnas, the Blue Crosses, the Blue Shields, certainly have their own system that is up and running and certainly seems to have some degree of cost control to it. So when I look at, what the Blues pay in, I'll go back to, my own firm's health insurance plan, you get an idea of what is paid. When I see what is being reimbursed by the Blues versus what is being reimbursed through workers' compensation, at times there's a significant difference between those two entities. So can we go to the Blues? Can we go to Aetna? Can we, take their model and perhaps tweak it a little bit for workers' compensation purposes? It's at least worth an exploration. Now, maybe the Bureau has been exploring that. Maybe they're simply waiting at this point before they do anything per the mandate of the Commonwealth Court for the decision to come down from the Supreme Court. But again, getting a handle on the dermatological creams, that's something that can be done, I believe, in this building to bring that into line. The Voltaren that was mentioned, that's a perfect example. You can buy it for $20 over at the local Walgreens. It's a 1% cream. Is that what is prescribed by many of these healthcare providers who are looking for an angle to perhaps raise the cost? No, they use a slightly higher dosage, which the tube is then 100 times the cost for a 2% versus a 1%. I'm not a mathematician, but it seems to me if you put a 1-inch stripe of 1% and a 1-inch stripe of 2%, if you just put a 2-inch stripe of the 1%, are you really in the same ballpark? I will leave that to the legal drug dealers in Pennsylvania to figure out the math. But yes, I think there are things that could be done.
Gotcha. Okay. Thank you. Well, gentlemen, thank you so much for your time. Workers' comp is a tough one for, I think, the general public to wrap their hands around. It's important to protect employees at all times and make sure I think we have the best employees in the world, hardest working, dedicated. We want to make sure they're protected and safe in everything they do. At the same time, we want to make sure we have a fair system that treats everyone equally and make sure we try to mitigate costs within that to make sure we have those employers coming to Pennsylvania and have jobs for those employees. So obviously, I think all the solutions laid out today are simple, common sense solutions to fix a system that is pro-worker and pro-business. So I thank you for your time, and we are concluded. Thank you.
Thank you for having us.
Thank you.